There we go. Hi guys, it's Kathy. I hope you're doing well. Whew, we made it so far. I'm just gonna tell you. I know we took a poll to see how many days are left in OJ. This was like 2 weeks ago, and you guys voted no. You didn't want to know, but now we're there. Tomorrow's the last day of the OJ trial. Is that crazy? After so long. Tomorrow's the last day of the OJ trial. So, it kind of sucks a lot, but listen, we really can't stand too much more of this. And we already know what happens tomorrow, but we still have a little bit of closing to go. So, if you remember, yesterday we stopped on Shaq handing the baton back to Johnnie. So, we're done with Shaq. We will not hear any more from Shaq. We're done with him. We're done with Newfield. We're done with Shapiro. We're done with everybody. The only people we get to hear now from the defense is Johnnie for a little bit longer. And then I don't know if both Marsha and Darden are going to talk tomorrow, or just one of them. Yeah, Zach, I can't. OJ killed my numbers for over a year. So I've trained YouTube that I have shitty numbers for over a year. So now it's time to rebuild the channel from the OJ drama. But it's fine. I wouldn't trade OJ for a thing. I loved doing OJ with you guys. It was so much fun. I almost wanted to just skip a day and go back to the preliminary hearing and watch a bit of that instead of doing the OJ today, but I'm not going to. We're in the middle of closing statements. It's not time to take a field trip. Field trip days are over. We had our field trips. No more. We're going to get to Johnnie.
Members, and Mr. Cochran, you may make your concluding remarks.
I'll be brief.
To my colleagues. Of the evidence with you.
He didn't actually say, I'll be brief, but it was damn close, wasn't it? Shut up, Johnnie, you liar.
You just heard what I believe was a remarkable discussion by Mr. Barishak. In this journey toward justice.
This is so stupid. I just, you just think that you were just streaming for 2 hours, so it would be fine. And no, you press play and it flips on you, and you don't even know. All right, here we go again.
Reflect that we've now been rejoined by all our jury members, and Mr. Cochran, you may make your concluding remarks.
Thank you, Your Honor. Judge Ito.
I'm going to go off stream and swear a little bit. Just a little bit of swearing.
Good afternoon. Again, ladies and gentlemen. Seems like we did this yesterday. But I won't be nearly as long this time. I'm back, as I promised you I'd come back, to try and wrap up the defense discussion of the evidence with you. You just heard what I believe was a remarkable discussion by Mr. Barishek, an excellent lawyer. He may be from Brooklyn, but he's become a Californian as far as we're concerned. He is a very valued member of our team of defense lawyers for Mr. OJ Simpson. And you see why. This is indeed a talented lawyer. And so he shared with you a number of things which I will not be redundant about and go over. You have them clear in mind. And if I were not to say anything else, there are many reasonable doubts in this case, and OJ Simpson is entitled to an acquittal based on what we have told you. This is my last chance, of course, to speak to you, and I want to take this time to tell you again that the prosecution, because they bear the burden of proving this case beyond a reasonable doubt, will have the opportunity to speak to you last. We may not be here too late tonight because I'm not going to be much longer, and I think that more than likely, I think we can probably guarantee this case is going to get to you sometime tomorrow afternoon, so you can kind of sit back and relax. It's been a long, long, long road to get to this point. It's been kind of like a relay race, hasn't it been, in many respects, in this journey toward justice. The prosecution was first running with it. We then took the baton and we started running with it. We've run almost up to the jury box. And soon, we're going to pass the baton to you. This is how our system works. This is what makes it so great. We pass the baton to you, and we'll be glad we can then sit back and watch you at work. You watched us for a year, 2 or 3 days. Now we get to watch you. It'll be symbolically watching you because we won't see you back in that room, but you know we're going to be counting on you, giving both sides the benefit of your individual opinion. Now it's your time to perform. You know how you could think about us in those days when you want to criticize us? We're not going to criticize you, though. We're going to just watch you work. And watching you work is what makes this country so great, because it's 12 citizens, good and true, coming together from this community from disparate backgrounds. Experience not required. Citizenship, the only requirement. To do justice, to do right, to right some wrongs, to straighten this out. That's what we're asking you to do. To follow the law, determine the facts, and come to a well-reasoned decision. That's what's going to happen tomorrow afternoon for you. Now, it may take 1 day or 100 days, but you've been committed. I know that you'll stay the course, keep your eye on the prize, and do the right thing. Now, when I sit down this time, I won't get another chance to argue to you or discuss the inferences because it has to stop sometime. But Ms. Clark gets to talk to you later tonight or tomorrow. And I want you again to use your common sense. And remember, if she raises some point, I may not be able to get up and respond, Mr. Sheck or I. If it's something that's not purely rebuttal, you may see more objections this time because we got to keep it in line. But if it's a point that we can't respond to, you substitute your wisdom and common sense as to any point. I think you know by this time we can answer anything that they would say. So I'm sure you'll give her the same attention you've given us today, and I wish them good luck. In fact, let me say this. In this case, we have been advocates. We have fought hard, I hope. But it's not personal. What is personal is this case. What is personal is our zeal and our desire that our client be acquitted. It's not personal against these prosecutors. In this part of our discussion, I want to share a couple of things with you and clear up a couple of things if I might. Remember, I was examining Detective Lang, and it was interesting that we saw Detective Lang here today. That's interesting, isn't it? Detective Lang was here. He's the only one who can really come anymore. We discussed the roles of these people. It's the only one who's going to show his face here, you can count on. But Lang says that early on that I asked him questions about traveling around the world to investigate this case, to get an idea of what resources were they putting on this case. You remember right at the very outset, the reason that robbery homicide was put on the case was because downtown they supposedly had better resources. There's some doubt about that, but they did that, and they put resources, including everybody in the LAPD. They had the DA's office and their investigators. They've had the FBI. They've been all over the world. You know, they've been everywhere looking for Bruno Magli's shoes. They've been to Italy. They've been to many of the states in the United States. And I asked them about those things to give you a scope of what they were trying to do. And you know, it's awesome, the power of the state. And at one point I worked as the assistant district attorney, so I know about power of the state. There's no priority to being on this side. I used to be on this side. You can be on both sides. It perhaps gives you a little different, a balanced perspective. But they have a lot of power. They can do a lot of things. They have a lot of resources. And they've used them in this case. So don't feel sorry for them. They've used every resource they had. But they didn't call people, there was a reason for it. It wasn't they didn't have the resources. These are excellent lawyers. They know the facts. If they didn't disprove something, if they couldn't disprove Henry Lee, if they didn't call anybody for John Gerdes, it's because they couldn't find anybody. Earlier, I talked to you about Detective Furman on this particular point. I wanted to make sure so we could be as accurate as possible. This question was asked by Bailey. There is a problem that has been brought to your attention, isn't there, Detective Furman? Answer, no. Question, when discussing this event in the preliminary hearing and talking about the glove, your tongue slipped and you said them, didn't you? Answer, yes. In case there was any question about what we'd said earlier. Mr. Sheck has covered the brush marks on the door, but what I'd like for you to do is look back at your notes, because Furman said that regarding these brush marks, he said he saw these marks on that door while the door of the Bronco was closed, remember? The reason why this has become so important was he was trying to say he hadn't gotten inside. Then we called Larry Regal, who said you couldn't see the ones at the top unless the door was open. And then Furman also had said that he told Fung about these brush marks. If you look at Fung's testimony, I think you'll find that Fung never says that he heard that from Furman. And so, you know, with regard to Furman, I could have gone on and on and on about lies, but that would be counterproductive after a while because you know who he is now. There's one other point I wanted to share with you about Furman before we take our leave of him, is that there was some questions in counsel at 18906 about opportunity for Detective Furman. And here was a series of quick questions. When you arrived at the scene this night, were you wearing a coat, a jacket of some sort? When I first arrived at the scene, yes. Can you describe it? Answer, a blue blazer. All right. And you were wearing the trousers and shirt that we see you in with your weapon in the picture pointing at the left-handed glove. Yes, tan slacks. Okay, now, at some point, did you walk back to your vehicle and take off your blazer and hang it to lay in the vehicle somewhere? Yes, sir. Okay. Can you tell the court and jury about what time of day that happened, bearing in mind that you arrived at about 2:10, that's a.m. It would be after I was relieved from the case. Now, he's relieved a short time after he gets there. He's relieved by 3 o'clock, isn't he? Before 3 o'clock. All right. That would be close to 3 o'clock? Yes, sir. Question. And that is when you walked back to the vehicle, and left the jacket, and stood waiting for your relief? Yes, sir. Now, I don't believe hardly anything he says, except that it is true that in this photograph taken at 4:30 or before sunrise, the one you saw where he's pointing at the glove, he doesn't have a jacket on. So he had a jacket, went to that car by himself. There's many things in that car. This man had ample opportunity to get up to that scene. You know, as I told you, it so stretches the credulity to believe that so neatly placed were this knit hat and this glove. Were there two gloves at some point? When he says, I saw them, how would you say them? There weren't two gloves. And, you know, it's so unusual because everything else is spread all out. This was a vicious fight. There's a beeper over here and there's keys over there. But these items are right there, right where you can point at them. It's two-pack. So you can ask yourself those questions when you go back into that jury room. Now, in this case, I discussed with you Miss Juanita Moore, a lady that I called, to the stand, and I think I misspoke myself. I think I mentioned to you that, I think I may have said, she said that Mr. Simpson did not have dandruff, and if I did say that, I got that wrong. She said that Mr. Simpson would get dandruff, I think, in the off-season, in the spring and summer when he was here, as opposed to when he was in New York, and I wanted to make sure, in looking at the transcript of the lunch hour, I noted that. Ms. Clark seemed to be amazed when Mr. Sheck said that
Johnnie.
Kelly Muldorfer said that she didn't see blood in that Bronco, so to save her some time, I'm going to read you the transcript. Kelly Muldorfer at 38268, lines 26 through line 9, I think 38269. Question, and when you looked at the console, do you remember seeing any blood there? Answer, no, I don't have any specific recollection. That's the lady, the investigator, who was looking at this. And so now we come to some jury instructions, which I think have some real relevance as we conclude this case, hopefully. We've already talked about a witness willfully false. We've talked an awful lot. You now know a lot about circumstantial evidence, and I dare say you know the difference between direct and circumstantial evidence. We won't talk further about that. And you know what happens where the proof circumstances are equally consistent, one of which points to innocence, the other which points to guilt, where they're both reasonable, you must adopt that which points to innocence. And you understand that. You understand about circumstantial evidence. So enough about that. And we've displayed this, and we talked about how this works and how it inures to the benefit of the defendant because there's this burden of proof. But there's another instruction which I want to talk to you about now, and this is one where the prosecutors keep wanting to change things around. And that's what we proved, what we didn't do. This is what the law is. The prosecution has the burden of proving beyond a reasonable doubt each element of the crimes charged in the information, and that the defendant was a perpetrator of any such crimes. There's no doubt about that among any of us, is it? The defendant is not required to prove him or herself innocent or to prove that another person committed the crimes charged. So now, if that's what the law is, and the judge gave you that, or Mr. Darden asked the question, who did this? Who committed this crime? Why would he ask that when the judge just said, the defendant doesn't have to show anything? And we know in this case, they rushed to judgment, they didn't look at anybody else. That's a question he should be asking these detectives, not us. We're the ones who had the preeminent experts who wanted to help out. They wouldn't accept them. Could he ask us that question? How could he ask us that question in good faith? So what the answer is, you go ask your detectives. That's the answer. Now, he asked another question. He said, well, where was OJ Simpson? And he says, well, how does he account for his whereabouts after 10 o'clock? Well, let me just take a minute about this. He asked that question. So let me answer it for you and for him. Some of you in your former life probably lived alone. If you lived alone, if something happened between 10 o'clock and 6 o'clock in the morning, it's real difficult, if you live alone, to prove where you were if nobody lives there with you. Isn't that true? Is that common sense? Mr. Simpson lived alone. Well, we've done more than that. We can establish where he was. He was at home. That Bronco was outside. He was packing and getting ready and rushing around at the last minute and coming outside to that Bronco, getting his phone, getting the paraphernalia for that phone. That's what he was doing. He was packing. He was getting the golf balls, the golf bag out of his car that was seated out there. He was getting golf shoes and whatever goes with golf if you're a golfer. That's what he's doing. He's getting this little knapsack out that has golf balls in it. And he was bringing another bag down, all of which were ready when Park, Cato were out there. And he comes down with the other bag, carrying it. That's what he was doing, Mr. Darden. That's where he was. It's your speculation. He's on the side of his house running into an air conditioning. That didn't happen. That's unreasonable. Nobody here believes it. It's not going to help save their case. They're speculating again. Speculating. Cynically speculating. And it's not going to work. And so that brings me to this other instruction. It's called alibi. You remember during voir dire I asked you about this. I said that you won't place a bad connotation on the term alibi. That's what the law calls it. Alibi. And it says as follows, that evidence has been received for the purpose of showing that the defendant was not present at the time and place of the commission of the alleged crime for which he is here on trial. If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Can I repeat that last part for you? If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed. It doesn't say you might find him not guilty. You might think about it. It says you must find him not guilty. And so, when you talk about this whole concept of reasonable doubt, and we'll talk a little more about that, it's how you feel inside about this evidence. It's how you feel inside about these messengers and their message. It's when you have that queasy feeling. You can't trust this evidence. Barry Scheck described it well as a cancer. He talked about one cockroach you don't need to see anymore, because if you see one, there's a lot of them around. All you need is one, and that's going to make you go the other way. In this case, you don't have to get past the socks. But then you get to the glove and the Bronco, and you get to all of it, none of which you can trust. And then how do you do it? Do you get back there and say, well, I don't trust him on this. I think I can trust him on that. When these essential link in the chain is broken, you've got reasonable doubt. And so your job won't be quite as tough as you may have thought. Reasonable doubt? In this case, the prosecution has not offered one coherent theory to explain how these deaths occurred. I won't talk about thanoparatus and the desperation that brought about, but let me talk to you about this whole concept of what took place in this case. One of the things that was intriguing to me, and I'm sure you've thought about it, and I know that your collective minds are far better than mine and Mr. Scheck's, but you know, we think about things that'll be helpful to you. You know, one of the things that's always troubled me about the prosecution's case is, you probably thought about this, Cato the dog was purchased by OJ Simpson after the other dog died. Remember, Orenthal told you about how they had to bury the dog, and it was a real tough time for the kids and all. OJ had that dog, Cato, along with Chachi, the other dog, over at Rockingham. And he let his son have the dog because they named the dog after Cato, who is now living over with OJ Simpson. That dog knows OJ Simpson. It's his dog. He bought the dog. They didn't know this as they were speculating. It's his dog. If OJ Simpson had been the one there that night, that dog would have followed him out the back gate. He wouldn't be going out the front. Those paw prints wouldn't be going out that way and down the sidewalk saw. That's common sense. They said use your common sense. They make sense to you. The other thing is, the one thing that you can count on in this case is these two people, even when they weren't getting along, loved their children. And their children loved them. Whether it was pediatric AIDS affairs, whether it was recitals, whether it was sunshine preschool affairs, just look at the month of May, the things that you heard that OJ Simpson went to. Always on the weekend because he was traveling. Wasn't no fuse, he was out of town working. He was the breadwinner. So whether it was the pediatric AIDS or something for his children's school at 400 people over at the Rockingham estate, he was always there for the kids. If it meant coming back from Chicago on Friday or from wherever he was in New York on Friday to go back to Chicago on Sunday to go back for an engagement, he came home. He came home because his little girl was having a concert. That's the kind of dad he is, and somebody has to stand up for him. People don't want you to stand up for him. People can't stand the truth, but they're going to hear truth in here. There's one place you can't take away somebody's voice, and that's in the courtroom. When you want to tell the truth. For 16 months, this man sat over here and heard people talk about him day in and day out, judged him and prejudged him against the American way. What right? How dare them do that? And he has 1 day or 2 days to have somebody stand up for him. And people are crying and moaning. It's outrageous in America. It's intolerable, if you will. And so this is a good and decent man who loves his family, who loves his kids. None of us are perfect. But he's a man who went a long, long way. Raised primarily by his mother, you know what he did with his life. He had a good life. A wonderful life. He's done well. Not going to give all that up? Try and kill somebody with a knife? He's not going to give that up. And you know what? If you think about this case, can you imagine that a man who loves his children so much is going to go over, kill his ex-wife, kill their mother, and leave her so that the children can come downstairs and find her? That defies credulity. None of you believe he would do that. It's contrary to everything that you can believe and that you've heard about this man and what he's done and what he's done with his life. So forgive me if I speak out for O.J. Simpson. If I'm so presumptuous as to believe that the Constitution means that you're presumed to be innocent until you make the decision. Nobody outside here has a vote. You have that vote, thank heaven.
Remember when he was beating her in front of the children? You remember that part?
These narrow-minded people, thank heaven they don't have a vote. You will have the final say. And so, this concept then of reasonable doubt. What then does it mean? We've heard about it. We've talked about it. We have a chart. I'm going to ask Mr. Douglas to put over there. Let's talk about this whole idea of burden of proof and reasonable doubt and what is reasonable doubt. You remember during voir dire I talked to you about this concept of reasonable doubt, and before we go to that chart, I mean, it's that state of the case. After the entire comparison and consideration of the evidence, leaves the minds of the jury in that condition where they cannot say they feel an abiding conviction of the truth of the charge. That's what reasonable doubt is, and let's go over it one more time because this is the cornerstone of every criminal case. What it really is a doubt based upon a reason. In this case, we have given you myriad reasons. There are many, 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 many reasonable doubts. It's not just one, all of which lead you to one verdict in this case, and one verdict only of not guilty, but let's go over it one last time together. A defendant in a criminal case is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving him guilty beyond a reasonable doubt. You've heard a lot about that. That's what people need to learn and be reminded of in this country. Reasonable doubt is defined as follows. It is not a mere possible doubt, and we know that, because everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case where, after the entire comparison and consideration of all the evidence leaves the minds of the jurors in that conviction, that they cannot say they feel an abiding conviction of the truth of the charge. That's reasonable doubt. It's not written just for OJ Simpson. It's for you. It's for you. It's for you. It's for all of us who are citizens. It's given in every criminal case. You have to give it. That's the burden. You don't change it once the trial starts. That's the burden. Let's see how it works. In this whole idea of a burden of proof, let's start down at the bottom and look at the burden that's placed upon the state. And they should have a burden like this. You're talking about taking somebody's freedom for the rest of their life or whatever. There are a number of things that you might want to think, but in a case, sometimes in cases, you actually can prove the person charged not guilty. And in this case, in my 32 and a half years, this may be as close as any case where somebody's been proven not guilty, because if you look at these facts, you look at what we've shared with you over the course of the last 2 days, this man has been proven not guilty. But that's at the very bottom of the rung. You may say, somebody among you may say, well, you know, I have some suspicions. I think it's highly unlikely, but I have some suspicions. Somebody else may say, well, it's less than likely, but, you know, I don't know. I mean, they didn't convince me beyond a reasonable doubt. And somebody else might say, well, you know, he's probably not guilty based upon this evidence. Somebody else will say, it's unlikely he's guilty. No way in the world is he ever going to go over and kill the mother of his children under these circumstances. The timeline shatters their case. Somebody says, I don't trust the police. Furman was central. I don't trust Van Adder. It's the messengers and their message. It just doesn't fit. Something's wrong. There's a cancer here. Possibly not. Guilty? Maybe not. As Mr. Sheck said to you, you know, maybe that's not good enough. You're talking about somebody's freedom for the rest of their lives. Well, then somebody else may say, well, perhaps. Gee, I don't know. I suspect that he might be. Maybe he's possibly guilty of something. Maybe he's probably guilty. Maybe guilt is likely. Maybe guilt may be highly likely. I don't think any of you are going to find this case, because I think we've shown that we've proven he's not guilty. But all of those levels, from proven not guilty to the guilt highly likely, is our interpretation of what you have to do before you get all the way up to guilt beyond a reasonable doubt, so that you won't have that queasy feeling about this case, where you can believe to an abiding conviction of the truth of these charges. Can you have that? I think not on this evidence. Not on this evidence, not on this case. They have failed. You know, we ask you a question. Did you have the courage? Did you have the intestinal fortitude to walk back into this courtroom? If they failed to prove Mr. Simpson guilty, did you have the courage to walk back in and say, we find him not guilty? And you said you could do that. That was part of your job. You said you could do that. I'm going to hold you to that, because that's what makes the system great. Your courage, your willingness to stand up for what is right. And so, in this scenario, thinking about reasonable doubt even more, the prosecution had a puzzle. And it was interesting how they did this puzzle. Technology is wonderful. And you saw they kept, under this puzzle, putting on pieces and that sort of thing. And so we thought about that. I thought about this puzzle. Thought about what it meant in this particular case. I got a call from a very, very wise lady who reminded me that if you've ever gone to the store and bought a puzzle, when you buy a puzzle, on the outside of the box of the puzzle, there's a picture. So you know what the puzzle looks like when it's finished. Well, in this case, the prosecution took a photograph or picture of OJ Simpson first. Then they took the pieces apart. If they really wanted to talk about reasonable doubt, you don't jump to conclusions at the beginning. You don't rush to judgment and then be concerned about an obsession to win. What you do is you take the pieces and put them together, and then you come to the conclusion. They got it all backwards. It's like what they did with the Fourth Amendment. It's like asking us, where is this witness? What did you prove? Solve this crime for us. They got it all backwards. Don't you see? And so that little example, a jigsaw puzzle, was clever, but really it trivializes a man's fight for his freedom, who's always said that he was innocent from day one. So I wanted to just summarize our sense with a graphic, thanks to Mr. Bob Blazer, of this evidence and why there's reasonable doubt as to each of these items. Please note the monitor. All right, let's look at first. We know in the upper left-hand corner
I'll be right back,
there's
guys.
missing blood.
I'm leaving a few
They
minutes
can't
early.
explain it,
I'll be
and they
back.
went down in flames, going out with a home video where it was actually embarrassing this morning. You want a little levity during the tough times in your deliberations? Play the Thanoparatus video. In fact, it's so bizarre that if you listen to it again, you'll hear Hank Goldberg is laughing himself. He starts laughing when, if you look at the words are mouthed by Paratus, he goes like that, and Goldberg starts laughing at his next question. How embarrassing this is, but this blood is still missing. You'll have that syringe there. So, Mr. Blazer and Mr. Harris, what does that mean, that missing blood? It means reasonable doubt. Then we have the socks, my personal favorites. And when I talked to you about the socks yesterday, I may not have told you that in addition to the socks not being in the video at 4:13 on June 13th, and how they placed them there later, and how they were collected at 4:35 or between 4:30 and 4:40, Willie Ford came in here and testified to you he didn't see the socks. Forgot to tell you that yesterday. He testified they weren't there either. So thank heaven there's one person who wasn't part of that cover-up, although they got to him and he was saying things, oh, well, the socks may have been covered. But he still works over there. So we'll forgive him for that, but he didn't know what we knew about Lang and Mazzola and the time they were collected in their log. Plus the timing on the whole thing got them. And those straps on the bed further. So what have we shown you about the socks? Reasonable doubt. That moves to the back gate. What about that back gate with EDTA and more DNA than you could ever imagine, and it's picked up and collected 3 weeks afterwards when people have been all over the place, and you saw the photograph? Look at that photograph. That photograph doesn't show any blood, it shows some little tiny spot. It's totally inconsistent. They're trapped again by the video. This case will go down as the video case because we have shown you for your own eyes why they lose this case, why there is reasonable doubt. So the back gate, reasonable doubt. And then we started out with the timeline because we knew at the outset the timeline with the witnesses that they failed and refused to call establish a reasonable doubt. It shatters the prosecution case. If you start there, you'll find these witnesses credible. OJ Simpson couldn't have committed these crimes. There's reasonable doubt. He's not guilty. The timeline. We went from there to the EAPB, and you'll remember that, and Mr. Sheck has talked about it. I won't be redundant. The double-banded B, that's somebody else. They can't explain it. They never tried to explain it, except to talk to you about something that's not in the literature. It didn't work. There's reasonable doubt about who that person was. And so, with regard to, and I see I've lost track of my chart there, demeanor, before we get to the EAPB, under demeanor. OJ Simpson's demeanor. All those witnesses who didn't know each other, who you heard, who they talked to, you saw them all. You think that he was acting for those people? Do you remember that one of the most interesting things was Mr. Darden said that when the Scott Kennedy video at the June 12th recital, where a man just happens to stop by and takes a video, Simpson doesn't even know he's being videoed. This guy doesn't know Simpson. He's just taking a video. Just came to us out of the blue. They had the audacity to tell you he was on camera. You didn't know anything about being on camera. Somebody's taking a video of you. How do you know that? But we had that video. And they have nothing else to say. You ever notice when they have nothing else to say, how they just say anything? That's an example of that. That's an example of O.J. Simpson's demeanor. And that was our answer to this so-called fuse. We had proof for you. You saw him on that date, and we took you through step by step through that date. We've already covered the EAPB, the Bundy blood drops that Mr. Sheck did such a great job on, and you know about those drops. You know the numbers as well as we do, and I won't go over those anymore. I think there's reasonable doubt based upon those. And, of course, you know the Bronco. How can you trust the Bronco? Chain of custody, how can you trust it? There's nothing you can trust about that Bronco and how they handle it. And then the gloves. The gloves didn't fit. The gloves didn't fit. The gloves didn't fit. Reasonable doubt. And then the why. Now, motive is not an element of the crime of murder, but absence of motive would tend to establish innocence. That's why Mr. Darden went to such a long and exhaustive study. And I've shared with you the fact that there is no motive in this case. But I just want to briefly tell you this about their theory at the end. If you believe what the prosecutors want you to believe, you have to believe that O.J. Simpson, who has a limo driver coming, I guess around 10:30, 10:40, after he goes and gets a hamburger at McDonald's, after having been worried about change because he had $100 bills, that he's already been packing because clothes are being brought down. He's taking his golf clubs because he is going to play golf, and that makes sense as a pre-planned trip. He's just off the road and going back on the road. that he is perhaps the most recognizable person in Brentwood in that area where he's lived, we know, for 17 years. That he drives a white Bronco. That he decides to put on a knit cap, and you saw that exhibition yesterday of him or you or I in a knit cap. He decides he'll put that on. He changes out of his tennis shoes, his Reebok tennis shoes, and his sweat socks, and puts on some dress socks. Puts on some Bruno Magli shoes. And let me just stop right there for a minute, put a pin in that. The Bruno Magli shoes, you heard all about Bruno Magli shoes and Bruno Magli shoes, and we searched all around the world, and we went to Bloomingdale's, and what did we find? There is nobody who ever sold OJ Simpson any Bruno Magli shoes. They searched, they tried, they never sold him any shoes. So they've just been talking about Bruno Magli shoes. I mean, there must be every other house in Brentwood. If somebody wanted to afford some Bruno Magli shoes, I guess they could. Now that's their case. There is no evidence that OJ Simpson had any Bruno Magli shoes ever. In fact, when Lang is looking for the clothes and OJ Simpson says, this is what I wore, here are the tennis shoes, he took only tennis shoes that night. There is no evidence that OJ Simpson ever owned any Bruno Magli shoes, and please remember that. So he puts these Bruno Magli shoes on, and he's trying to disguise himself, of course. He puts on a pair of gloves that don't fit, and he gets in his car, and he decides that what he'll do is he'll drive over to the alleyway behind Bundy where his wife lives in this big Bronco. Now, while he's going to do that, he's been over there a number of times, and you know, they've already told you about Pablo Fenves and these people who live back there. You remember when you went on that jury view? There are homes and windows and things that face down on that alley, on both sides, from, I guess, Gretna Green side and from the Bundy side. People are looking down in that alley. It's well lit. You saw the photograph yesterday of what Mark Storfer would have seen. He pulls into this alleyway in this Bronco, in this disguise, dressed the way they want to have him dressed. So he's come and kill his wife. Now, somehow, they're trying to kill his wife or whatever. He doesn't kill her in the back there where the car is. He goes and lures her to the front gate. Doesn't make any sense, does it? He goes to the front gate to lure her to that front gate. And then he gets into a fight, somebody he doesn't even know. This fight goes on for 5 to 15 minutes. The fight is so fierce that a hat and a glove are torn off. That's how fierce this fight had to be. The keys, the beeper. You saw how tough it is for any kind of an altercation. For gloves to come off, for a hat to come off, there's kicking, there's all kind of fighting in this small area. But that's what they want you to believe. And so we find the keys and the beeper and the gloves, of course, we find specifically the cap and the gloves neatly packaged under the item there. And then he leaves this one glove behind and then just walks slowly out to the alleyway. Now, the dog that we heard so much about, who he bought, who was his dog, doesn't go with him. He goes the other way, out the front to go down the other way. Cato, the dog, under what they would have you believe. And he's got these bloody clothes on and everything. Now he goes back out there where his car's been sitting 10, 15, 20 minutes, right out there in the alleyway. Anybody could look, anybody coming home, people are driving up and down the street. Gets back in his car, then presumably he races back home where the limousine driver who's there doesn't hear him come up, doesn't see him, doesn't do any of those things. And we know from the time they see OJ Simpson, within 5 minutes, he's coming downstairs, packed, luggage is already down there, looking neat as a pin, heading for the airport. Now, he was expecting this man after he came back from the hamburger. This is what their case is. This is what they want you to believe. And just for good measure, that's not enough. That's not enough. Under their scenario, once he gets home, after he's rushing, he's got enough time, he's got all these bloody clothes on, he runs down the side of his house, where he's lived for 17 years, and runs into the air conditioning. It says, oops, no marks, of course, on his body, but while he's back there, he drops a bloody glove to match the other glove found over at Bundy. And just for good measure, so they'll be sure and find it, he knocks on the wall. He doesn't run into the wall, he knocks on the wall. He says, he gives a signal. Then he decides he comes in the house, but nobody sees him do any of that. That's what they have you believe. That is the prosecution's case. We have been here 1 year, ladies and gentlemen, and 2 days to hear this is what they have told you. It just doesn't fit. If it doesn't fit, you must acquit. Something is wrong with the prosecution's case, and your common sense is never going to let you fall for it. So the other side, of course, we submitted in answering the questions that O.J. Simpson was at home getting ready for his trip. He had no problem with his ex-wife. He had gone to this concert. She had gotten the tickets for him. There's no argument. Nobody's come in here, so they had any argument that day. There's no fight. They talked earlier, made arrangements for the tickets. He went to the concert. You saw him at the concert. You traced his steps that day and what he did. And then he went on to Chicago and came back immediately. And everything he did was consistent with innocence. This case is a tragedy for everybody. For certainly the victims and their families. For the Simpsons family. They're victims too because they lost a ex-daughter-in-law. For the defendant. He's been in custody since June of 1994 for a crime that he didn't commit. Someone has taken these children's mother. I certainly hope that your decision doesn't take their father and that justice is finally achieved in this case. One final word about Alan Park. We talked a lot about Alan Park. He's somebody that Ms. Clark, of course, found credible. But even credible people don't get everything right. Remember the golf bag? He thought it was a blue golf bag, and we know it's black with an insignia on it. We know that there was a lot of questions asked about whether you saw a car parked at the curb, and I read you the portion that when I questioned him where he said he hadn't really been looking. He was not very clear with regard to that. But like all witnesses, you hold them up to the same standard and look at them. And so now, I promise you we're going to coming to the end. If after hearing all of this evidence, you have a reasonable doubt, it is clear that OJ Simpson is entitled to an acquittal. And whether it is OJ or no J, the result would have to be the same. His status doesn't count. It's the evidence that counts and what's been proven to you under these circumstances. But he is a good and decent man who you have seen and observed every day we're in session since September 26, 1994. Now, as it comes time for me to conclude my remarks, I may never have an opportunity again to speak to you, certainly not in this setting, maybe when the case is over. As you've been told many, many times, there is a very heavy burden placed upon the people, and for good reason, to prove this case beyond a reasonable doubt. As such, it is Ms. Clark's duty to answer for you, as best she can, any legitimate questions arising from the evidence, which we believe casts doubt upon Mr. Simpson's guilt. There may be 1,000 such questions in a case like this, which can be put to her, but we intend no such exercise. I do think, after careful deliberation, that it might be fair to suggest 15 questions, just 15 questions, which literally hang in the air in this courtroom at this moment, and as the time approaches for you to decide this case, for us to hand the baton to you. I offer these questions now as a most important challenge to the prosecution. The prosecution which claims that it's met its burden in this case. If that burden has in fact been met, you will be given logical, sensible, credible, satisfying answers to each of these 15 questions. If the questions are overwhelming and unanswerable, they will be ignored, or you'll be told that the prosecution has no obligation to answer the questions. If you're given anything less than a complete, sensible, and satisfactory response, satisfying you beyond a reasonable doubt to these 15 questions, you will quickly realize that the case really is transparent, and you'll think about the scenario that I just went through for you, and that the term smoke and mirrors that you heard about doesn't apply to the defense. We proved real, hard things for you, things that you can see, things you can take back in that jury room. And accordingly, you'd have to find Mr. Simpson not guilty. When I've concluded, for Ms. Clark's convenience, should she decide to deal with these very troublesome questions, I'm going to leave a written list of these questions here when I conclude. Let me go over these 15 questions with you just briefly. 1. Why, there on the monitor, did the blood show up on the sock almost 2 months after a careful search for evidence? And why, as demonstrated by Dr. Lee and Professor McDonald, was the blood applied when there was no foot in it? Think that's a fair question? In this case, let's see if she can answer that question. Question number 2. Why was Mark Furman, a detective who'd been pushed off the case, the person who went by himself to the Bronco, over the fence, to interrogate Cato, to discover the glove in the thump, thump, thump area? Number 3. Why was the glove still moist when Furman found it, if Mr. Simpson had dropped it 7 hours earlier? As Agent Bodziak told you, Sir McDonald has told you, blood dries very rapidly. 4. If Mark Furman would speak so openly about his intense genocidal racism to a relative stranger, such as Kathleen Bell, How many of his co-workers, the other detectives in this case, were also aware that he lied when he denied using the N-word, yet failed to come forward? Part of Barry Scheck's fourth C of continuing cover-up. 5, why did the prosecution not call a single police officer to rebut police photographer Rokar's testimony that Detective Furman was pointing at the glove before Furman went to Rockingham? That is around 4:30 in the morning. 6, if the glove had been dropped on the walkway at Rockingham 10 minutes after the murder, why is there no blood or fiber on that south walkway or on the leaves the glove was resting on? Why is there no blood on the 150 feet of narrow walkway or on the stucco wall abutting it? And you've been back there. Number 7, for what purpose was Van Adder carrying Mr. Simpson's blood in his pocket for 3 hours and a distance of 25 miles instead of booking it down the hall at Parker Center? Number 8, why did Deputy District Attorney Hank Goldberg, in a desperate effort to cover up for the missing 1.5 milliliters of Mr. Simpson's blood, secretly go out to the home of police nurse Thanoparatus without notice to the defense and get him to contradict his previous sworn testimony at both the grand jury and the preliminary hearing? Paratus was never sworn. We were never given notice. 9, why, if according to Ms. Clark, he walked into his own house wearing the murder clothes and shoes, is there not any soil or so much as a smear or drop of blood associated with the victims on the floor, the white carpeting, the doorknobs, the light switches, and his bedding? 10, if Mr. Simpson had just killed Mr. Goldman in a bloody battle involving more than 24 knife wounds where Mr. Goldman remained standing and struggling for several minutes, how come there is less than 7/10 of 1 drop of blood consistent with Mr. Goldman found in the Bronco? Number 11, why, following a bitter struggle allegedly with Mr. Goldman, were there no bruises or marks on OJ Simpson's body? And you'll have those photographs back in the jury room. Number 12, why do bloodstains with the most DNA not show up until weeks after the murders? Those on the socks, those on the back gate, those are the 2 major areas. Number 13, why did Mark Furman lie to us? Why did Phil Van Adder lie to us? And finally, 15, given Professor McDonald's testimony that the gloves would not have shrunk, no matter how much blood was smeared on them, and given that they never shrank from June 21st, 1994 until now, despite having been repeatedly frozen and thawed, how come the gloves just don't fit? I'm going to leave those questions for Ms. Clark, and we'll see what she chooses to do with and about them. That'll be her choice. But I think you have a right to demand answers. If you're going to do your job in this case, it seems to me you will need to have answers to those questions. Now, there are many, many, many more, but as with everything in this case, there comes a time when you can only do so much. We took 15 as representatives, but I can tell you we had more than 50 questions. But 15 will be enough, don't you think? I think so. In this case, when we started out a long time ago, we talked a lot about truth. And I always like, in a circular fashion, that you kind of end up where you started out. Truth is a wonderful commodity in this society. Some people can't stand the truth. But you know what? That notwithstanding, we still have to deal with truth in this society. Carlyle said that no lie can live forever. We've seen a number of big lies in this case, in this so-called rush to judgment. We've seen lie after lie, so much so that at least 2 of the major witnesses, Van Adder and Lang, Van Adder and Strike That and Furman, their testimony by you may be totally disregarded, further dismantling the people's case. You have that right, you know, in this search for truth. In times like these, we often turn to the Bible for some answers to try to figure out, when you've got situations like this and you want to get an answer and you want to try to understand. I happen to really like the book of Proverbs. And in Proverbs, it talks a lot about false witnesses. It says that a false witness shall not be unpunished, and he that speaketh lies shall not escape. That meant a lot to me in this case, because there was Mark Furman, acting like a choir boy, making you believe he was the best witness that walked in here. generally applauded for his wonderful performance. Turns out he was the biggest liar in this courtroom during this process. But the Bible had already told us the answer, that a false witness shall not be unpunished, and he that speaketh lies shall not escape. In that same book, it tells us that a faithful witness will not lie, but a false witness will utter lies. Finally, in Proverbs, it says that he that speaketh the truth showeth the forthrightfulness, but a false witness shows deceit. So when we're talking about truth, we're talking about truth and lies and conspiracies and cover-ups. I always think about one of my favorite poems, which I think is so very appropriate for this case. You know, when things are at the darkest, there's always light the next day. In your life, in all of our lives, you have the capacity to transform Mr. OJ Simpson's dark yesterdays into brighter tomorrows. You have that capacity. You have that power in your hand. And James Russell Lowell said it best about wrong and evil. He said that truth forever on the scaffold, wrong forever on the throne, yet that scaffold sways the future. And beyond the dim unknown standeth God within the shadows, keeping watch above his own. You walk with that every day. You carry that with you. And things will come to you, and you will be able to reveal people who come to you in uniforms and high positions who lie and are corrupt. That's what happened in this case. And so the truth is now out. It's now up to you. We're going to pass this baton to you soon. You will do the right thing. You've made a commitment for justice. You'll do the right thing. I will someday go on to other cases, no doubt, as will Miss Clark and Mr. Dart. Judge Ito will try another case someday, I hope. But this is O.J. Simpson's one day in court. By your decision, you control his very life in your hands. Treat it carefully, treat it fairly. Be fair. Don't be part of this continuing cover-up. Do the right thing, remembering that if it doesn't fit, you must acquit. That if these messengers have lied to you, you can't trust their message. That this has been a search for truth. That no matter how bad it looks, if truth is out there on a scaffold and wrong is in here on the throne, remember that the scaffold always sways the future. And beyond the dim unknown standeth the same God for all people, keeping watch above his own. He watches all of us, and he'll watch you in your decision. Thank you for your attention. God bless you.
Thank you very much, Mr. Cochran. All right, let me see counsel over the sidebar without the court report, please. All right, ladies and gentlemen, contrary to our previous schedule, I'm going to recess for the evening at this time. We will resume tomorrow morning at 9 o'clock, and the lawyers have promised me that we will finish this case. One of the conditions that we go over until tomorrow morning is that we will finish tomorrow afternoon with the rebuttal arguments by the prosecution, I will instruct you, and the case will be yours tomorrow afternoon. And I hopefully we'll at least get it far enough to have you go in, select a foreperson to preside over your deliberations, and then Mrs. Robertson has a list of the exhibits and everything that will be presented to you so you can get organized for the coming days. All right, having said that, please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. We'll see you tomorrow morning, 9 o'clock sharp. All right, we'll be in recess. All parties are again present. Deputy Smith, let's have the jurors, please.
We address the court on just an issue or two.
One issue, yes.
Your Honor, when I began my closing argument yesterday, there was an objection that Ms. Clark made with respect to improper vouching, but she misheard the testimony because I said we believe the evidence shows an innocent man wrongly accused, and I realize that was a mistake on her part in objecting, and the transcript bore it out. However, I do have some concerns here with respect to improper vouching. I think it is improper to make an argument to the jury that Marcia and I are the ones with courage. That is classic improper vouching. I don't think a district attorney is allowed to say that in closing argument, and that's why we objected. I think it's improper for the district attorney to talk about, I prosecute police officers, so I know. The implication is there, A, don't worry, I'll take care of Mark Furman, I'll prosecute him. B, if Detective Van Adder is lying, don't worry, I would know that. I think that's improper vouching. I think it's improper to make an argument, everybody knows he's guilty. That's wrong. I don't think that that kind of argument is permissible. I think it's impermissible if they wanted to call an expert about domestic violence. That's one thing, but I think it's impermissible to say I know a lot about certain things with respect to domestic violence issues. And most importantly, there was this whole thing where they put up the video where, as was indicated, the court had ordered that that part be redacted and indicated deception. But worst of all, he then makes an argument that Dr. Lee that infers to the jury or directly states that those shoe prints could have been left by those officers taking the blanket away when Agent Bodziak specifically testified, agreeing with Dr. Lee that they could not be. So that directly misstates the evidence. Finally, I would make this request, because this is the prosecution's rebuttal summation and we do not have a chance to get back up. And if there were misstatements of evidence in their opening closing arguments, we were able to get back up and retranscript and correct it. If we make an argument with respect to misstating the evidence, I would respectfully request that if the court is going to overrule it with the caveat, which I know is the thrust and substance of the court's ruling, the jury's recollection controls, because I think that's the fair and neutral way to do it. And so I make that request of the court, and I would also request the court caution counsel and that we have no more of this improper vouching, because I think it's an improper form of argument, and I'm talking about those specific matters.
All right, this matter submitted? All right. Objection is noted. They're overruled. Let's have the jury, please.
There are a couple of photographs. There are a series of photographs of officers that the prosecution expects to show that I was just shown during this break, during Ms. Clark's presentation. Now I have an objection I want to lodge.
What's your objection?
Well, I object. I think it's very similar to what we wanted to show the photographs of Mr. Simpson with the gloves on. That was a still. These are photographs of Risky and the various officers, Lang and the others, and we object. And with regard to the last two photographs that I was shown, it still has the KTLA Channel 5 logo on those. So I wanted to lodge my objection, having just seen these things at this point. I think it's analogous. I think it's what the court has said. I haven't seen these before, and I presume they would be pictures would put up there as she would be testifying about.
Is this four photograph?
No, I think they're one at a time, as I understand it. And you can see them if you care to.
They're still photographs of the.
Really, mostly the police officers. I think Mazzola's in there also.
Yeah,
I went through the list.
I just told Mr. Copper when he said he was going to object to this that the court overruled my objection. I had objected to the stills that they were going to use. They elected not to use them ultimately, but the court overruled it saying the stills were proper. So I made this exhibit on that ruling.
Well, again, you of course see the last two with the KTLA seal, and.
Well, the KTLA seal is irrelevant,
I
counsel.
thought it was irrelevant, but you had us cleared up before, I thought. But you had to cover that up. That was the
That's at a time that where the source of it was not relevant to the issue.
All right.
All right.
Your Honor, one more
Noted.
objection I want to note for the record, and that is I also think it was an improper argument that Mr. Simpson gave his bags to his lawyer on the way in. First of all, there's no facts in the record establishing that Mr. Kardashian was in the act of representing Mr. Simpson at that point in time, or that there was any attorney-client relationship at that point in time. And I think it's a highly inflammatory and improper argument, and also does not accord with the known facts in the case. And another one I think they came perilously close to with respect to the discussion of darkness at Bundy. And that is, we all were at the scene. Now, Mr. Darden wasn't. I appreciate that on the night that we did the jury view. And I have no objection to him citing from certain specific points in the record, but I would just like it noted, we all know what the lighting was like there. because we recreated the best we could. And then the prosecution chose not to take the jury on a nighttime jury view. It was their decision. And it seems to me that in terms of good faith arguments based on what is knowledge of all the parties here, that I think they have to be very, very careful in terms of raising inferences to the jury about what could be seen and couldn't be seen in light of what we know.
Well, what we know is from a recreation counsel, the testimony of the witnesses as to approaching that walkway under conditions of darkness on June the 12th and June the 13th are in the record, and it's a fair inference. The argument's concluded, counsel.
I understand that. I'm just saying that
Sit down.
that was probably too close.
That's a fair inference that can be drawn from the record. Also, I'm going to admonish counsel on both sides not to make any gestures, head shaking, grimaces, or any other responses to a counsel's argument. I've seen it on both sides, and if I see it again, I'm going to stop in front of the jury, and I'm going to upbraid you in front of the jury. Let's have the jurors. Both. Ladies and gentlemen, please be seated. Record to reflect we've been rejoined by all the members of our jury panel. Just want to make sure we're safe. Mr. Darden, you may continue.
Thank you, Your Honor. Good morning again. I'm just about done. Just about done. Because I'm very anxious to get this case to you so that you can resolve it, so that we can have some closure as it relates to this case. One of the things that was mentioned the other day was something about Robert Heitstra, and you remember Mr. Heitstra. He was the witness who had the laminated letter from F. Lee Bailey saying that he was going to be an important witness for the defense. And much ado was made about Mr. Heitstra and why we didn't call him, we the prosecution didn't call him, and I think it was suggested that we didn't call him because he didn't fit our timeline. Well, they don't know what we're thinking. They can't read our minds. They called Robert Heitstra in the defense case. They don't know whether or not we were going to call him in the rebuttal case. They don't know that. Robert Heitstra is a very important witness. They called him. Fine. As long as you heard the testimony, that's all that mattered. He testified that he left his house around 10:15, right? Isn't that what he testified to? He said he saw the clock in his apartment, as I recall. He left with his dogs. He left on a walk. He walked around the block, halfway around the block. And as he approached Bundy, he heard these dogs barking. And he told you that it was around 10:30. And I asked him some questions. I asked him, did you look at your watch when you first heard those dogs barking? No. All he could do was give you an approximation as to what time he heard those dogs barking. And in his best estimate, his best guess was about 10:30. And so he says he heard Cato, the dog, bark around 10:30, and that he changed directions and walked down that alleyway. He walked down the alley, on the opposite side of Bundy. That is the side opposite from Nicole's condo. He walks down the alley, and as he walks down the alley, he heard someone yell, "Hey, hey, hey." And he stopped, and he paused. And he told you that that "hey, hey, hey" voice sounded to him to be the voice of a young man. And he also told you that he heard the voice of another man, an older man perhaps, with a heavier voice. Remember that? Remember that? And he continued to walk down that alleyway, and when he got down to Dorothy, he looked west toward Bundy, and what did he see? What did he tell you he saw? He saw a vehicle coming east from the direction of the alleyway that ran up behind Nicole Brown's condo. It was his vehicle. It was the defendant. I asked Mr. Heinster, what color was that vehicle? He said it was white, just like the defendant's vehicle. I asked him if the vehicle had tinted windows. He said it did. You look at the pictures of the defendant's Bronco, tinted windows. Yesterday, someone stood up here and said to you, Heinster never said anything about Bronco. He said a Jeep or a van. I asked Mr. Heinster about the vehicle he saw. And he told you right here on the witness stand that the vehicle he saw was a Blazer or a Bronco. I asked him specifically. I asked him that specifically at pages 36,339 and 36,471. And at 36339, he told you, he testified. He was a defense witness. He testified that the vehicle he saw could have been a Bronco. He didn't look at his watch. He didn't look to see what time it was when he first saw that Bronco. And what did that Bronco do?
Counsel, ladies and gentlemen, you've heard all the evidence. As I indicated to you when we started these arguments, counsel may argue to the evidence and draw reasonable inferences from that evidence. However, you are the exclusive judges as to what facts exist from the evidence in this case. Proceed, counsel.
Thank you, Your Honor, and that's true. But this is their witness. This is Robert Heinster. That's what he testified to here in the transcript. It could have been a Bronco. It could have been a Bronco. That's what he said. Chevy Blazer or a Bronco. Remember that? And I asked him a question. Okay, well, you're saying Chevy Blazer or a Bronco. I asked him a question at page 36471. I asked him, Mr. Heinster, a Chevy Blazer and a Ford Bronco looks very much alike to you, doesn't it? And his answer was, yeah, they look alike. Certainly, from a distance. I would suggest to you that the vehicle Heinster saw leaving Bundy that night was a white Bronco. It's a white Bronco that has all that blood in it. It's the white Bronco that's parked askew at the defendant's house. This is their witness. And I said it the other day, and I'll say it again today, I don't care what the time is. It doesn't matter. It doesn't matter at all. He didn't look at his watch the time that he saw that Bronco or that Blazer. And I asked him about that, and I asked him if he looked at his watch, and he told us he didn't look at his watch. And then I asked him how long it would take to get from Bundy to the defendant's house, because as you recall, Mr. Heinster watched cars, detailed cars, for the Salingers, the people that lived directly next door to the defendant's property. And I asked him at page 36413, counsel, at line 3, I asked him, Mr. Heinster, would they have enough time to drive to 360 North Rockingham and arrive by 10:52? His answer, yes, you could do it. Yes, sure. And I went on to ask him, you could arrive there by 10:45, correct? Line 14, page 36413. And at line 15 on that same page, his answer was right. Yes. They want you to believe that Cato Kalin heard the thumps at 10:45, and Ms. Clark will explain to you how it is that we extrapolate some of the facts, some of the hard facts in this case, facts that can't be disputed, and we consider all the testimony and facts that help establish what time Cato Kalin actually heard those thumps. But it doesn't matter. Kalin says 10:45, and that's his best estimate. Mr. Heinster says, hey, there's enough time to drive that Bronco from this death scene, this scene of murder, to the defendant's house. And finally, we get to gloves. Finally, we come around full circle once again to the issue of gloves. And I watched one of the defense lawyers stand up here and pull a watch cap over their head and ask you what they looked like. if it changed their appearance? Well, you know, in a lighted courtroom at the intersection of Temple and Bundy, it probably doesn't change his appearance at all. Especially after somebody's been standing up in front of you for 2 to 3 hours. But the issue is, would it change his appearance? Would it affect one's ability to recognize him if it was 10 o'clock at night? How about 10:03? Will it affect your ability to recognize him in the dark? And what if he had on dark cotton sweats? And what if it was dark out there in front of that condo the way Officer Risky described? Or what if he had a big knife? These little demonstrations that we saw. And then we saw one of the lawyers struggle with a pair of gloves. These are your gloves. These gloves are size small. Fitness gloves are extra large. We heard so much about the scriptures. I'm not even going to read it. Just read Proverbs 6 one day when this is all over. Now, if I'm the messenger, you know, I delivered the message as best as I could. And the message is that he killed these 2 people. And that's what the evidence dictates. You know, they mess around with our science evidence and stuff and try to cause you to lose confidence in that evidence, but Marshall Clark will go back and go over some of the points we think you might be interested in hearing about to sort of straighten that out. But I know that you're going to do a good job when you go into the jury room. All I could ever ask from you, and all that I ask from you today, is that you try and be as objective as you possibly can be. That you not allow any passion or emotion or any bias, any of that human feeling, those human feelings we all have, to interfere with the decision you have to make. When I stood before you back in January, I said there were many victims in this case. And there are many interests involved in this case. It's an important case of OJ Simpson. And it's an important case to the victims and their families. We just want you to be fair. I just want you to do the right thing. That means the right thing under the law. We believe we've proven this case beyond a reasonable doubt. And it's unfortunate. It's unfortunate what jealousy does to you. It's unfortunate that obsession. It's unfortunate that obsession can do these things to you. It is unfortunate that 2 innocent people are dead because they got in this man's way. That's the message we wanted to deliver. And I'm the messenger. And I'm proud to have delivered it. I thank you for your verdict in advance. In the event I don't get a chance to talk to you then, all of us owe you a debt of gratitude. God bless you.
Ms. Clark.
Good morning. How are you? I'm not allowed to ask you that, I just realized. Excuse me. I know you're tired of hearing us talk. I'm going to get right into the evidence because I want to go through what they said. I want to show you how the evidence corrects that. And I want to talk to you about logic. I want to talk to you about what makes sense, okay? Because you've been hearing a lot of stuff that really makes no sense. You've been hearing lawyers spin stories and spin yarns for you with no evidence to it. Not only does it have no evidence, but it has no logic. And in that specifically, I'm talking about this story about Mark Furman swiping the bloody glove inside the Bronco. Well, that's a story. That's an interesting story, but it has no substance. Not only does it have no proof to it, but it also has no logic to it. And I'll show you why. And that's what I want to talk to you about now. Logic. What makes sense? In this case, we have seen what the defense has done, and it's been a very contorted, very inconsistent thing. I'm going to point out the inconsistencies to you. But basically, they have jumped from we are stupid bumblers or we are brilliant conspirators. And he includes us in this. And I find that particularly painful, ladies and gentlemen, particularly painful, because I've been doing this a lot of years. I didn't start here. I started on that side of counsel table. I was a defense attorney. I know what the ethical obligations are of a prosecutor. I took a cut in pay to join this office because I believe in this job. I believe in doing it fairly and doing it right. And I like the luxury of being a prosecutor because I have the luxury on any case of going to the judge and saying, guess what, Your Honor, dismiss it. It's not here. Ladies and gentlemen, I can come to you and I can say, don't convict. It's not here. I have that right. I have that luxury. This job gives me that luxury. It doesn't give me a lot of money, but it gives me that luxury. I can get up in the morning and look at myself in the mirror and say, I tell you the truth. I will never ask for a conviction unless I should, unless the law says I must, unless he is proven guilty beyond a reasonable doubt on credible evidence that you can trust, that you can rely on. I can never do it otherwise. That's my obligation. And that's why I'm standing here before you today, because we have proven it to you, ladies and gentlemen. If I thought for 1 minute there was a conspiracy...
Be seated. Ladies and gentlemen, would you have a seat at your case? All right, records reflect the jury's withdrawn from the courtroom. Ms. Clark, the last comment that you made, if I thought for a minute there was a conspiracy,
I would finish it. It would be my obligation to dismiss this case.
We're close here, counsel.
Your Honor, in view of the...
This has been
Wait.
highly improper. I'm sorry.
Sit down.
No, sorry.
You're close, Ms. Clark. I realize it's not a complete thought, but what you can't argue is what the evidence shows. You can argue ethical obligations that prosecutors have. I'm just cautioning you that you're close here. You're close to the line. You're not over it yet.
Thank you, Your Honor. I was...
Mr. Scheck,
Excuse me, may I just ask for one point of clarification? The thought as I completed it is acceptable, is it not?
it is.
All right.
But the eyes, every time the eyes get in there,
Yes. The only... Let me just mention this. I have never had a defense attorney make an argument like Mr. Cochran made, nor have I ever seen a defense attorney get up and ask for jury nullification in this way. But when they do...
it was very artfully phrased.
I'll reserve comment. But what I'm saying, Your Honor, is that when a defense attorney does take the gloves off that way, hit below the belt the way Mr. Cochran does, the law permits us to argue our ethical obligations. The Court's aware of that. Under People v. B, under U.S. v. Wade, we have the right then to argue what our obligations are. I get to tell the jury the truth, that I have a luxury they don't have, a luxury I didn't have until I joined this office. They have to represent guilty people and stand up before the jury and say it hasn't been proven, no matter how well it has been proven. I
I'm sorry,
don't have
counsel,
to do
you're
that.
objecting to her argument to the court?
Yes, I object. Your quiet, please. I object to that. I think I have right to do that.
Anyway, these are not remarks that I make to the jury, but when counsel takes off the gloves, makes personal attacks the way he has, saying basically that we're criminals, then we have the right, under the law, to correct that misimpression and to tell the jury we have ethical obligations that prevent us from pursuing a prosecution unless we believe 100%.
There's the problem.
Okay,
Unless you believe the evidence shows it.
right,
You have to be clear. You cannot infer that you have personal knowledge beyond the state of the evidence.
right. Agreed. No question. I wouldn't do that.
Mr. Scheck,
Your Honor, they already have. They've gone over the line. Now, as the court noted, the argument yesterday, and it's one that these prosecutors have to live with, is that they put Mark Fruman on the witness stand. He testified in a way about, Mr. Cochran accurately cited the record. He read from it, talking about how he went through all this terrible personal anguish and all these outside issues were raised, and he was presented as a totally credible witness. Now these prosecutors have to get up in front of the jury and say he's a racist and a liar. They have to do that because that's what happened. The jury is allowed to consider the fact that they were plainly taken by surprise by the perjury of their own witness. They also have a right to consider the fact that other officers probably knew these facts and never came forward. That's fair argument and fair comment on the evidence. What's unfair argument and unfair comment and clear law is for a prosecutor to stand up and say that I prosecute police officers, Marcia and I are the ones with courage, and then to go on now and say that she used to be a defense lawyer and now she's a prosecutor and she has the luxury of dismissing cases if the evidence is not there and coming forward if she thought something was exculpatory, etc., and then vouching personally for the reliability of the evidence is a highly, highly improper form of argument in this state, every state. They've gone way over the line, and it's really got to stop. It's really got to stop. And I don't like to sit here and constantly say objection, 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 objection to improper forms of argument, and the court is being patient and controlled in terms of overruling it, but this is way, way over the line. I mean, I've been teaching law for 18 years, And I never heard this kind of stuff. And I dare say that people, it's amazing. It's amazing. They cannot say it. And what's particularly galling is that they're saying it when they are the ones that have to live with the fact that one of their principal witnesses perjured himself after they put him on. It hurts. But Mr. Cochran's comments with respect to that are fair on the evidence. And trying to vouch in this fashion is improper rebuttal, an improper form of argument, period.
What I heard also was you can't trust the messengers and you can't trust the message.
Well, those were...
And wait. And Mr. Darden clearly cast himself as a messenger in his argument. That was a clear shot at the integrity of counsel on this side, and they're entitled to respond.
Wait a second. I think that's incorrect, and please hear me on it. Mr. Cochran's arguments yesterday, Mr. Darden got up and said, I'm just a messenger sending you evidence. Mr. Cochran got up and said, the messengers in this case are the witnesses. The messengers are Mark Furman, oh, he did, and Van Adder. He talked about these messengers being deceivers, and that is the argument. Now, I don't see how the court can allow this kind of vouching if you are inferring that there's some kind of, metaphor crossover here. Mr. Cochran has a perfect right, it is a total fair comment on the evidence, to talk about these prosecution witnesses as messengers. If Mr. Darden chooses to cast himself as a messenger too, well, that's fine. But I didn't interpret that as a comment on Mr. Darden. It was a turn of phrase, and he specifically talked about these witnesses. And to the extent that Mr. Cochran is pointing out that Mark Furman was put up there first as a credible witness, and now they have to admit that he's a liar, as they did, and they're distancing themselves, that's fair comment. What's unfair comment is for them to get up here and in this fashion vouch for every other witness and every other piece of evidence in a highly improper form. They've gone way over the line. Way over the line.
Cite me a case, counsel.
That's not what she
California
did.
law dealing with comments of counsel.
Well, Your Honor, you have discretion here, and we all know the basic principles in terms of the
And I
American
have
Bar
cautioned-
Association,
I have cautioned them, counsel.
rules. I'm sorry?
Well, the California State Bar is a bar that is unto itself and has its own rules, counsel.
I've read the Giona's case, and I understand that they can say things that you can't say in other jurisdictions about smoke screens and the rest of it. But in this jurisdiction and in every other jurisdiction, there are rules about vouching, and they've gone over that line.
Well, here's the
We want
problem.
instruction. I think the court
counsel.
should at least give a balanced.
No, she didn't. She is directly responding to comments they made in their closing statement. She is responding to those. She is not over the line. She is not wrong.
Instruction at this point to the jury that it is not the prosecutor's personal views or personalities or anything else about the evidence that govern. It is their view of the evidence, and they should take that. I think we are entitled to an instruction like that at this point.
What a prosecutor may not do is a prosecutor may not express personal opinion
Was that
or
on the
belief
red
in the
ribbon?
defendant's guilt, where there is some substantial danger that the jurors will interpret this as being based upon information beyond the evidence produced at trial. I have not heard that yet.
That's a different improper form of argument. And I think actually Mr. Darden was pretty close to that when he was talking about everybody knows, and yesterday he was saying things like, he's a murderer. I think he actually went over that line, but let's put that aside. What I'm most
Are
concerned
you
about
saying
now...
that there is a substantial danger that when a prosecutor stands up and says that the defendant accused of murder is a murderer, that goes over the line?
No. I'm saying that you just read in terms of a prosecutor's obligation. He's got to say things like, the evidence shows we submit. And I think that in terms of rhetoric, he went over that line. But let's put that aside. What I'm most concerned about, and the court, frankly, is not addressing here, the court can't be seriously suggesting that a form of argument that says, we are courageous, we know our ethical obligations, we are telling you that this evidence is correct. If I thought there was a conspiracy, I would come forward and tell you all that. Everything they've been doing this morning is an improper form of argument, it's improper vouching, and, Your Honor, I think you know it. And I think that we have to have an instruction here.
No.
You're close here, Mr. Scheck.
No, but no. If the defense team said the prosecutors were involved in this, she is 100,000%, even my dog agrees, allowed to respond to that. They just are. You can't just get up there and say whatever you want about the prosecution and then say, oh no, they're not allowed to talk about that. What the heck? He's been teaching law for 17 years.
Thank you. All right, Ms. Clark, I'm cautioning you, though.
I understand that.
People versus Bain, 5 Cal 3rd, 8:39, the court's comments at 8:48.
I'm aware.
You're cautioned.
Yes, Your Honor. I'm going
I don't want to hear any more ayes.
Right. You won't. I'm ready. I'm ready to no more say, no more ayes.
Deputy Smith?
All right, all right. Do we get any more sidebars and motions and not objections? Of course, we're going to get objections. So does the closing arguments get stopped anymore? That's what we have to guess right now. I'm going to say no. I'm going to say we get through it now. Bobby, did you get the extra spicy EDTA today? No cherry on top of coffee. No, Bobby. No. Because, John, because that defense team can do whatever the hell they want to do. Period. And Marcia gets shit on. Period. Or should I tell you how I really feel? I hope this is the last time I have to fast forward this. Whatever. It's good enough. Hold on.
Ladies and gentlemen, please be
There we
seated.
go. We got it.
Let the record reflect that we've been rejoined by all the members of our jury panel. Ladies and gentlemen, as I indicated to you earlier, argument is a very important part of the case. It's the opportunity of these lawyers to actually bring everything together in a logical and coherent way. And I indicated to you that the lawyers may argue the evidence that is in the record and draw from that evidence reasonable inferences for you to consider. Those are the guidelines. I needed to discuss a few matters out of your presence with the lawyers. We're ready to proceed. Ms. Clark.
Thank you, Ron. Once again. So, as I was saying, if there is evidence of a conspiracy, it would be my obligation to dismiss. Pure and simple. And I can go on to the next case.
Overruled.
But there isn't. And in this case, we have...
Overruled.
I'm going to finish what I have to say to you, and I'm going to do it as quickly as I can. Okay. What we have here is logic and evidence and common sense, which when you weave them all together, you can see what the truth is. You can see what's really happening here. I'm going to start with a very simple example, and that is the arguments that were made to you about the notification of the coroner to the coroner. You might remember that counsel made a big deal about the fact that the coroner wasn't called till late, and Mr. Cochran has repeatedly referred to the rush to judgment. Now let me address that with you for a second. The rush to judgment. The argument has been made that when they went to Rockingham, what they really wanted to do was make an arrest, right? Rush to judgment. They had it in mind that they were going to go there and arrest him, and he was a suspect, and there was a reference made to a remark made by Mr. Van Adder in January or February of this year that seemed to contradict what he was telling you about his state of mind. Now, I don't know about you folks, but what I do when I have a doubt, when I wonder about what somebody really means, whether I can believe them, I look what they do. Look what they do. Like we were all taught as kids, actions speak louder than words. Yes, they do. Yes, they do. People can say things. We all know they can. But let's see what they do. Now, what did they do? Okay, let's look back at the evidence that is not contested, the evidence that stands unrefuted. They were out at Bundy. Commander Bushy told the initial detectives, get on out there, go and make notification at Rockingham. You know that would be a problem for somebody who's famous, because if the media finds out it's all over the place, that's a very painful thing. And Commander Bushy sure doesn't want it to happen on his watch that would happen in this case. So he told them, go out there. That's what he told you. Did they? No. They weren't sure if they were going to keep the case. I'm weaving the testimony for you together without reading from the transcript. You have it, though. I'm not going to bore you. But Detective Phillips did say, we weren't sure if we were going to keep the case if we had the resources. That was a real big problem with this case, because they only had, I think he said 4 or 6 detectives in homicide over in West L.A. So they thought that it might be taken over by Robbery Homicide Division downtown that has many, many more detectives and more resources. Before they act, before they move to make notification, which is an important thing to do in a homicide case, your first contact with next of kin is to go and make the notification, make that contact, establish that rapport. And there might be some information that you can get from the next of kin or the person you notify that could be very helpful to solving the case. The person could be a witness, okay? Now, especially in this case where they have children in common, he might know who she's dating or not, because, you know, they're divorced, but they still have to have contact. He might know something. It's an important first contact for them to make. So whoever is the handling detective is the one that's supposed to go. This is the testimony you've already heard. I'm not telling you anything new. So they waited. They waited until they found out if Robbery Homicide was going to take the case, and sure enough, they did. That's what happened. Van Adder and Lang came out there. And I guess they showed up around 4:30, I think it was. All right. So they were standing out there waiting for quite a long time. Now, when Van Adder and Lang got there, or in between, I think, when it was finally assigned to robbery homicide, Commander Bushy spoke to them again and said, go to Rockingham. You know, how many times do I have to say this? Go and do it. So then finally, they still didn't go and do it. They still didn't run out there, okay? That was, I can't remember, I think he said it was around the time, he couldn't be specific about the time, that's right. But he said he knew that Van Adder was there, that robbery homicide had taken over the case. Now, Van Adder didn't get there, I think, till 4 or so. The record will refresh your memory. I can't remember exactly, I'm not trying to tell you I am. But it was that time. Even then, they didn't go immediately. It was, I think, about 5 o'clock when they finally went to Rockingham. Finally went there. Now, think about this. There were a lot of questions asked about why couldn't you have sent a rookie to go and make notification? Okay, now you know that doesn't make sense. If notification is an important thing, first of all, it has to be handled delicately, sensitively, by people who have done this before, many times before, homicide detectives. It's one of the saddest parts of their job. They have to make these notifications every day, but they know how, and they know how to deal with it. Bless you. So they're going to go and do it themselves. It's an important contact. That's their job. That's their duty. Okay? So they can't send a rookie out to do it, but what should they do? Think about this now. If it is their intent to go out to Rockingham, make an arrest, because he's a suspect, there are certain things they should have done. Number one thing is you take backup. You don't go by yourself. You take backup. You take a couple of squad cars, you make notification downtown, hey, we're going to arrest him, this is an important suspect, and this could be a big media event. You make plans, you make arrangements. They did nothing. Zip. They went out there and they took just the 4 detectives in their 2 cars. They went over to Rockingham. That's all they did. What else should they have done? Ask yourself. If they know
Excuse me,
that...
counsel. Overruled. They may argue reasonable inference from the evidence that is in the record and has counsel have a seat.
Your common sense will tell you I'm not misleading you. This makes sense. I'm talking logic. I'm also talking logic based on what the witnesses have told you. You know it when you hear it. Now, what else should they have done? If they're going to go make an arrest, that's going to take some time. They could really get wrapped up. They could do questioning. They could take downtown. They could, the things that happen when someone gets arrested. So, if they know they're going to take a long time, they have a crime scene that has to be processed, they have 2 dead people lying out there, and all that evidence around, what would they do? They would go to somebody who's going to stay at the crime scene and they would say, call the coroner, we're going to be gone a while. Call the criminalist, we're going to be gone a while. We need you to get this evidence collected, and we won't be here because we're going to make an arrest. Did they do any of that? No. Now, what the evidence has shown is, and what they've testified to, and what their actions tell you is true, they expected to come right back. 2 of them would stay with Mr. Simpson, taking care of him, taking him to the station to get his children, making the arrangements, and 2 would go back to Bundy and handle the crime scene. And their actions totally support that. If they expected to be gone a long time, they wouldn't all forego. Or they would tell someone else, take care of business for us, we're going to be gone. They didn't do that. What their actions tell you is, we're coming right back. It doesn't really matter if somebody isn't taking care of business and calling the coroner and calling the criminalist. Logic. Logic. Look at their actions. Look at their actions. You don't trust the words? Look at what they do. That's what they did. Right now, an argument was made to you about standing the Constitution on its head. And that's because I said, look, why don't they call these witnesses? There are witnesses they should logically call. Now, I'm talking about logic. I'm talking about reason. I'm talking about what do you expect? What would you like to hear? These are questions you're entitled to have answered. These are questions that you should consider. These are fair and reasonable questions, and these are questions that do not stand the Constitution on its head. I told you when I first argued to you in the beginning of all these long arguments that they would be telling you many, many times, the defense, we don't have to prove anything. If you heard it once, you heard it 50 times. They did. That's what they said. And that's right. They don't. But when they do, but when they try to, then you have to evaluate their evidence the same as ours. There's no difference. The jury instructions govern all the witnesses. And so you look, what is the quality of evidence that I've been given by the defense? What witnesses have they called? What logical witnesses that you would expect to be called weren't called? That all tells you something. It's legitimate for you to consider it. You must consider it because, as I showed you in the jury instruction beyond a reasonable doubt, you must consider all of the evidence. That means everything that was done and not done. And here's an example. Thano Paradas. Remember that? That was the nurse. He drew the blood. That was their witness. Now, he was their witness because he was the cornerstone of their case. Very important to make you believe that there is missing blood. But then, now, I think defense counsel made some reference to that, the notion that Hank Goldberg, secretly went out and interviewed him. What's secret? You know, if you have a question about this, ask the judge. No attorney for either side is required to give notification to the other side, oh, I'm going to go interview my witness. That makes sense, doesn't it? They don't notify us, we don't notify them. We talk to them. We give them evidence of it. We give them a statement. Here, we talk to this guy. Here's the statement. That's what we do. Hank Goldberg went and talked to him. Mr. Parada said, no, I didn't measure. No, I didn't look. And I realized I was wrong. I was trying to be very precise. Okay? Now, here's the syringe. You're going to have this back here. You look at it. And what he said was, I turned it over. I had it turned over, and I couldn't see the numbers. And you'll see when you look at the numbers and all these little lines, unless you're sitting there like this, you're not going to be able to measure precisely how much you've got in there. But if you have it turned over, you're really not going to know. Okay? But beyond all of that, it just kind of makes sense. If no one tells you you must take this much blood, you're not going to look to take that much blood. You're going to take enough. You take enough for sampling, for testing, and that's what they did. Now, final paralysis is not truly a real important part of our case because we prove to you in many different ways the integrity of the evidence. I'm going to get into the blood evidence and why it's proven to have integrity in just a little bit. Let me start with hair and fiber, though. Jonathan, do we have those? Thank you. All right, now, there were a number of misstatements made to you yesterday by Mr. Scheck concerning the hair and fiber evidence. I'm going to go into just a couple of them. And one thing that Mr. Scheck said was that Mr. Diedrich and Dr. Lee agreed that hair and fiber association was weak association. Well, here's what Dr. Lee testified to, page 43,168. Question posed to Dr. Lee. Do you agree with the following statement? While it is difficult to make absolute individualizations in these areas, the trace analyst can make identifications with a high degree of certainty and can often establish partial individuality of a specimen with confidence based on experience and analytical results. Answer. I would say 80 to 90% that statement correct. They forgot one thing, depends on samples. Not all the sample you can reach that degree of certainty. Some of the samples, yes, you can. In other words, it's a very good, what he said, can establish partial individuality with confidence. In other words, it's a very strong method of association. Now I'm going to show you the pictures, and you'll see why they make that strong statement.
Page 43,168 only took them 16 weeks to get through in the trial. We remember it well.
This is people's 480. Remember this? Because no one had hairs on the top row, and then the hairs from the knit cap at the bottom row. And you look at them, and you compare, and you see. Your eyes tell you. You don't need to look at x-rays. You don't need to look at autographs. These were the hairs in the knit cap found at the feet of Ron Goldman. This is testimony that was unrefuted. No defense expert came in to tell you this wasn't so. And people's 481. Again, the defendant's known hairs. Hairs taken from the knit cap. Hair from Ron Goldman's shirt. You can see this.
Wow, Zach, you're an expert. You're an expert in hair and fiber now.
Mr. Scheck also told you that the blue
Zach,
black.
and now that I just literally said that, you can even say, I've been told I'm an expert in hair and fiber.
Cotton fibers that were found on Ron Goldman's shirt on the.
Bobby, you're an expert in hair and fiber. Now, Bobby, if you want a great pickup line, you also can say that you are you've been called an expert in hair and fiber.
Rockingham glove and on the defendant's socks were very common. That's what he argued to you yesterday. That
True.
is not what the testimony said.
What song was
Let
it?
me read to you what
What
Dr.
song
Diedrich
was
told
it,
you
Josh?
about this. Page 35,093. Question. Now, you saw a lot of fibers in this case, correct? Answer. A lot, yes. Question. Was there something unusual about these particular blue-black cotton fibers that drew your attention or made you pay particular attention to them? Answer. Yes. Well, cotton fibers themselves, they are common. There is a lot of cotton fibers out there. What gives cotton fibers significance is that when you add color to them in a specific way, some you see more, maybe less likely than others. These are actually, it is a real dark blue. It looks black, but in some areas the dye was not absorbed the same, and this may be where the yarns are attached to the fabric. The same thing appeared also on the fibers that were recovered from Ron Goldman's shirt, the bluish area, also present here. It was recovered from the defendant's socks. The bluish area here is starting to show. Some of these areas can better be shown using instrumental techniques with color because the eyeball sees this as a shade of blue, this as a shade of blue, and so forth. And then he goes into all of the methods that he used to examine these blue-black cotton fibers to determine that they did in fact share the same microscopic characteristics. And I was going to read it all to you, but it's just too long. There's a lot of tests that he used, and it had to do with the color, it had to do with the dye, it had to do with the appearance, and if you need to have it read back, please do, but you also have a picture. And if you don't want to read it, you'll see it. Equals 487.
If you could show that briefly to counsel. All right, thank you.
And you can look at these fibers. Look, there's a Rockingham glove, Ron Golden shirt, there's Bennett socks. These are things you can see. Now, there was also some discussion about the defendant having dandruff, if you recall. And it was told to you that the defendant always had dandruff in the off-season. That is not what the testimony showed. Here's what the testimony actually showed about that. Page 37,441. Question. And sometimes in the summer, when you saw him take care of his hair, he would have dandruff, and sometimes he would not. Answer. That's correct. That was his barber. The other interesting thing that she told us is that unless you brush the hair vigorously, the dandruff does not come off. So I asked her, if you just brush his hair, the dandruff doesn't come off? Answer, right. Which means if you don't brush or comb the hair and it just falls off by itself, the dandruff doesn't come off. If you don't do anything to the hair, I guess it will just stay there. Now, the hairs in the cap did not have dandruff. And the defense wants you to believe it couldn't be his hair because he has dandruff. That is not what the testimony showed. That is not what the evidence showed. The evidence showed sometimes he does, sometimes he doesn't, but actually, even if he did, it wouldn't come off in the knit cap because you had to brush vigorously to get it out so that it would show. So what you have in the knit cap are his hairs, the naturally shed hairs that are his, because he wore the hat. Jury instructions. I spoke to you a little bit about them before. There was one I didn't talk to you about. I want to mention now because I'm going to talk a little bit about Dr. Bodden and what he testified to. And that instruction is 2.80. Do you have it on the bench, Your Honor? 2.80? Wait, I have it. Thank you. You have a few instructions. It tells you about expert testimony, and this can be really helpful to you because I think I'm not alone in getting a little bit intimidated by experts. They know, they have doctor in front of their names, and what do I know? But you shouldn't be. You shouldn't be. You are allowed to evaluate the opinion of a doctor, and if it doesn't make sense, you can say, you don't make sense, I don't believe you. It doesn't matter if they have doctor or PhD before or after their name. You get to evaluate it because if it's not logical, if it doesn't make sense, it doesn't matter what their title is. And that's basically what the instruction says. 2.80, you'll have it back there, and it says the following. You are not bound to accept an expert opinion as conclusive, but should give to it the weight to which you find it to be entitled. You may disregard any such opinion if you find it to be unreasonable. Okay? So what that tells you is, don't be intimidated by the title. You know what makes sense, and if you find it to be unreasonable, toss it. Okay? Dr. Bodden told you some things that that made absolutely no sense. They defy the laws of gravity. What am I talking about? I'm not going to drag all the pictures out here right now. You'll have them back there if you want to verify this. One thing that he said that I just couldn't believe I was hearing is that the jugular vein cut was the one that caused the blood on Ron Goldman's pants. Now, think about this. This is jumping blood. because there isn't a big, then it should be dripping down the shirt, right? Logic tells you that if he's bleeding from the neck, it's going to drip down his shirt and then get to his pants. You look at his shirt. It's not there. The front of the shirt is not blood-soaked and front over the place where the pants are all blood-soaked. So it's very obvious that where the blood came from is the stab wound in the hip. And Dr. Bodden's testimony on that makes absolutely no sense. Another thing that makes no sense, that actually disregards what gravity tells you must be true, but what I think what Dr. Lakshmanan told you as well, and he is medically qualified, and that is this. He also said, and this is how he gives you this big time frame, which, by the way, makes no sense all by itself, and I'll talk about that in a minute. He said that there was a period of between 5 to 15 minutes from the time that the neck wound was inflicted to the time that the chest wound was inflicted. And he based that on the very small amount of blood found in the chest cavity on Ron Goldman's right side. Okay? In other words, what he's basically telling you is that blood pressure had so dropped as a result of this jugular wound. He bled out so much that by the time he got stabbed here, it had to be about 10 minutes later, and that's why there's so little blood in the cavity. Okay? But Ron Goldman was lying on his right side and bleeding out so much, you can actually see it in the photographs you'll have back there. There was a tree stump that I think has the number 106 on it. When you have the photographs, look at this, please, because it's blood-soaked. And what they did, well, before they got the actual reference vials of the victim's blood from the coroner, was they went and they took blood samples from the place where the victims were lying so they would have some idea ahead of time as to what the victim's blood types were. So they took a swatch from the tree stump near Ron, because obviously that was his blood. They also took a swatch from the pool of blood that Ms. Brown was lying in. And that was her reference sample taken from the crime scene. That's how much he was bleeding out. Dr. Bodden doesn't believe in gravity, doesn't believe that that's why he had so little blood in his cavity, doesn't believe that somebody lying on their right side is going to bleed out if he's lying there for a while, and says there's so little blood there, that means he was already near death, and that means the jugular wound had been bleeding for quite a long time, and that's ridiculous. I'll tell you why else. You don't even have to be a doctor to figure this one out. Somebody commits murder, they're going to hang around? What was he doing for 10 minutes? Between the time that he inflicts the jugular cut and the time that he inflicts the chest cavity, if you believe Dr. Bodden, he's got 10 minutes to kill. The door is standing open. There's no evidence of ransacking. There's no evidence of disturbance. What's he doing? Playing solitaire out there? What's he going to... That's ridiculous. What are they asking you to buy? That's why I'm saying, look at the jury instruction. You may disregard any such opinion if you find it to be unreasonable. Ladies and gentlemen, that is one of the most unreasonable things I think I've ever heard any doctor say. That is ridiculous.
Sorry, if you would slow down just a little.
I'm
Sorry, if you would slow down just a little.
I'm sorry. I'm trying to get it over with, so I'm sorry. I'm sorry, Chris.
You remember when Shaq and Cochran were up there screaming very, very, very fast? Not once did the judge break into their closing statement and say, "Can you please slow down?"
While we're on expert testimony, EDTA, very, very briefly. Okay. You were told during argument that a letter was sent to Agent Martz asking him to refute the allegation that the blood was planted. That is not what the letter says. The letter says, I didn't bring the exhibit number, Your Honor, I just
All
have
right,
the letter.
supply the force. All right, I'll just... All right, proceed.
The question posed was, we would like you to test these items for the presence/absence of EDTA in order to refute the possibility that the stain on the sock could have come from this reference sample. Now, what is the point of that? When we heard that the defense was going to make this outrageous allegation, I thought, well, I won't close my mind to anything. Let's find out. Right.
Be careful.
So we sent the reference samples, and we sent the sock, and we sent the rear gate samples to Agent Martz for testing. Let's find out. And what was the result? No EDTA. No big surprise, but no EDTA. Now, he came in and he testified, and he showed you these charts. And I want to show them to you one more time, because it made it so clear. And perhaps you may recall, he tested his own blood, unpreserved. He tested the evidence on the gate, and he tested the blood on the sock. And guess what? His own unpreserved blood and the gate stain and the sock stain all came out looking the same. They came out looking like this. and taped all their charts together. So what you see here is the results of all of those things. That's 544E, Your Honor.
Thank you.
Okay? That was Agent Martz's own blood and the evidence. That means the rear gate blood and the sock blood. That's what that looked like. So unpreserved blood and the evidence had all those jagged peaks. Okay? Here's 544F. This is what it looks like when we have EDTA preserved blood. All the same. That stuff all comes from the test tube with EDTA in it. Does that look anything like the jagged peaks that we just showed you? That's pretty easy. But Dr. Reeders thought he could get you to blind your eyes and listen to his title and say, well, gee, I'm not qualified. Maybe they do look alike. I mean, it's ridiculous, but he did that. And he insults your intelligence with this. But what's even worse, and what shows you really that this is a man whose opinion is for sale, is that his initial report said, I found 2 of the 3 ions on the gate and on the sock. And he thought that was going to be good enough for him to say, well, it could be consistent with, and he could slide around with that. One unfortunate thing that happened after he wrote that report was, Agent Martz then said, gosh, I wonder what it would be like if I tested my own blood without any EDTA in it. Took blood out of his arm, and he went and he tested it with not an EDTA, just regular old blood. And guess what? It looked just like the gate. It looked just like the sock. Well, when Dr. Reeders found that out, he realized, I've got to do something, because they've just proven me completely wrong. So what he did for the first time on the witness stand was, he got up there and he said, oops, I found another ion on the sock. And he tried to show you that one of those peaks matches something else. It was really reprehensible. And I know I got a little bit excited with Dr. Reeders, but this is a man, does not forget where he comes from, does not forget what he did before. I asked him questions about this other case, the case of poisoning. You may recall, case of oleander poisoning, in which he was asked by the district attorneys of Ventura County and this county to find out whether a man died of natural causes or had been poisoned to death. Now, that sounds pretty serious, doesn't it? That's a murder charge that can or cannot be brought based on what his test shows. And he did preliminary screening tests. He did not use state-of-the-art. He didn't even know what state-of-the-art was available at the time. And he came back with the answer, yes, poison is present. Poison is present. And had the DA and the defense attorney not joined together to go out and find an expert who had much more sophisticated equipment who could do definitive testing, an innocent man would have gone to prison for murder. Because Dr. Reeders was so sloppy and so out of date and had an opinion for hire for whoever was bidding, that's what would have happened. But fortunately, the DA said, no, we're going to go and check that again.
Counsel, that does go beyond the scope.
And that's why you have to view very, very carefully the experts. See if they make sense. See if you can rely on them. See if they are believable. See if they are logical. And consider the fact that they're for hire. Sure, that makes a difference. Dr. Bodden, who came and told you that gravity doesn't work, paid over $100,000 in this case. He's very charming. He's very affable. I enjoyed seeing him in court, but hearing him was something else. Over $100,000 he got paid in this case.
Yo, wait, what? Okay, guys. Defense teams across the world, I am available to tell you that EDTA doesn't matter, or does, I don't care. $100,000, I'm available. I'm available to testify as an expert witness because I just sat through the OJ trial. So trust the fact that I know. I know my stuff now. And I'm available to hire for $100,000. Just tell me what you want me to say. I can finish my doctorate if you want me to first, but I would just rather you pay me.
There was also a reference made to you. Mr. Darden began to address it about golf balls. You may recall. And then it was argued as well. It was argued that the defendant had that little dark bag that he insisted on picking up, and that was for carrying golf balls to the tournament in Chicago. Now, first of all, what kind of sense does that make? You take your own golf balls to a golf tournament? Don't you think they're going to give you some there? But it's worse than that because that's not what the evidence showed. Alan Park was specifically asked about that. Can you tell us, sir, whether you saw any golf balls in that lawn area that night? Answer, no. Cato was asked the same question. Did you ever see balls in relationship to a bag that was similar to the bag you saw in the driveway on June the 12th? No, I don't think so. I don't remember seeing that. I think there were balls in the garage, kind of just balls that were there.
I saw that movie, though.
And that was a question asked by Mr. Shapiro of Cato Kalin. So not only doesn't it make any sense, but there's no evidence to support it at all. Now, there was something else said to you, represented, that Mr. Kalin and pictures and a videotape also refute, and that is a side door. You may recall that defense counsel mentioned to you, why would it be Mr. Simpson walking in through that front door when Alan Park was sitting out there watching him? He could have gone in from the side. Not true. And the evidence proves it's not true. First of all, Mr. Kalin testified that the laundry room referred to by counsel was not really used. But we have better than that for you, ladies and gentlemen. We have a videotape. We have that inventory videotape that counsel brought in that shows that door, that shows on June 13th that there were things, a little step ladder and stuff like that in front of the door, which gives you a clear indication that door was not in use. And that's the condition of that area on the afternoon of June the 13th. Do we have a clip?
What exhibit is
Bless you.
What exhibit is this, Mr. Fairlow? All right, thank you, Mr. Wood.
Laundry room. Oops, back up. That was quick. Okay, see the laundry room in there?
Marcia's cups have grown throughout the trial. Remember when they were
See that
giving
step
her
ladder?
that little Dixie cup?
See the stepladder? See the bag of laundry? It's stacked in front of the door.
Counsel speaks for itself. All right, the counter's at 3:01 p.m. Thank you, counsel.
Thank you. Now, do you put a stepladder, do you put a basket of laundry in front of a door that you use? No, obviously not. So there was no other way in, and that is why.
Wait, is there
Alan
something
Hart
wrong
saw
with
the
that?
defendant walking in the door that night. And I'm going to tell you something, ladies and gentlemen. That was the defining moment of this trial. That was the one. Because when you understand that the defendant was out that night, when you understand that he lied to Alan Park about being asleep, when you understand that that Bronco was moved and that he was out in that Bronco that night and that 10:03 call to Paula Barbieri is because he was out there making that phone call, then you understand how the defense falls apart. Then you understand where he was when his whereabouts are unaccounted for. And Alan Park's testimony is unrefuted. Alan Park came in and told us the truth, and he told it consistently. Bronco was not there, and neither was the defendant until 10:54. Excuse me, thumbs on the wall, 10:52. Now that's one more important point.
Overruled,
That's
counsel.
another important point, and this is why phone records are a good thing. And you'll have the testimony. I'm not going to read to you anymore. You're probably tired of hearing that. You have it in the record. I asked specifically, Cato, did you look at a clock? Did you look at your watch when you heard that thumping noise on your wall? No, I didn't. So is this an estimate? Yes, it's an estimate. He's estimating because he's not looking at what time it is. He says, I called Rachel around this time. About a half an hour later, I heard the thumps. It's an estimate. We had to go with that until we realized that Alan Park had a phone record. He had a phone record that said when he made a call and said when the call ended. And it was at the end of that call to his boss or from his boss that he saw Cato Kalin out in the side yard. And Cato Kalin told you, and it's unrefuted and it's uncontested, that it was 2 to 3 minutes after the thumping that he was out in that side yard. That's what he told you. And that means that the thumping occurred at 10:52. And then Alan Park saw Cato in the side yard at 10:54 at the same time as he saw the defendant walking in the door, 10:54. That means that 2 minutes after the thumping, the defendant is going into his house. And that means the thumping was done by the defendant. And they want to make fun of the fact that he ran into an air conditioner because it's his property and wouldn't he know better? Well, I don't think that he hung out on the South Pathway a whole lot.
Marcia, dear love, none of that came out during the trial because of all your freaking words and witnesses. None of that information came across to the jury during the trial. If you would have just presented it in that fashion, That's a big deal. That was a big, big deal. It's the first time I've heard it.
That's not where Mr. Simpson would go. That's where a repairman would go. Maybe a maid would go. He doesn't go down there. And anyway, that dark and that
Overruled.
that dark and that narrow little pathway in a hurry, when you're pressed and you're frantic, you're not going to be looking to see everything that's coming. You're running. You're running. He's in a hurry. And that's why that happens. Now, there was also some statement about there was nothing around that glove, but Dr. Lee said differently. Page 43,200. Question. Now, in addition to that, doctor, when you were at the Rockingham location, did you have occasion to find any item that, in your forensic opinion, was consistent or appeared to be blood in the area of air conditioning unit near Cato Kalin's house? Answer, yes, sir. It's in the records, Your Honor.
Hold. With the court report, please.
Okay, that's enough. The defense team is just giving me gray hair, pissing me off. I really, 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 really hope the judge nails him for this one, because she's allowed to give her closing statement. This is just stupid. Anyway, thanks for coming out, guys. I really appreciate it. Tomorrow's the last day. Tomorrow will be the last day of OJ. We might go a little over 2 hours, but I don't think by much. Definitely, maybe before 2.5 hours. But we get to the end tomorrow. So I appreciate you coming out today. I really do. I'll see you again real soon. I hope you guys have a great day. Bye, guys.